Hi, I'm Dale Hunt. I am a patent attorney and a plant scientist. I've been doing patents now for 24 years since I finished law school, and I've been a partner in several national firms. I started my own firm called Plant and Planet Law Firm in 2019, and I'm also the founder and CEO of a company called Breeders Best, which we created to help cannabis breeders protect their IP and license it to markets and patients worldwide. So today we're going to be talking about the protection of intellectual property for plant breeders and how, with that IP protected, they can also license their creative work. I hope you enjoy the talk, and thanks for joining us. We're going to format this talk along the lines of some frequently asked questions that I get all the time from people in the industry, and I think that's a good way to kind of communicate some of the issues that people seem to care about. So the first of these is patenting cannabis genetics even possible? Next, we'll talk about how do I know if my plant is patentable? And then, do I need a DNA analysis or sequence in order to patent it? Can I just open source my plants? Is it ethical to patent plants? Okay, we're going to stop. And finally, what can I do with patent rights once I've obtained them? So, first of all, is patenting cannabis possible? The answer is a resounding yes. But before I get to the yes, I want to point out that you're going to see something at the top of these slides. It will be a highlighted hyperlink to a blog post. It turned out, as I was preparing this talk, I realized that I had written a blog about every one of these topics. And so I would invite you to go to plantlaw.com and peruse the topics there, and I think you'll find some things that are of interest. Okay, so back to the resounding yes. You can patent cannabis. Many people doubt that because they've heard about how it's impossible to get trademark protection from the USPTO for any kind of mark that touches the plant, if it's a high THC plant. And that's an interesting thing. It is the Patent and Trademark Office, and what people who aren't lawyers haven't ever really had to notice or deal with is the fact that the trademark statute, which governs the administration of the trademark side of the office, is very different from the patent statute. To get a trademark, you have to use the mark in commerce, which means between states, and it has to be legal use, federally legal use. In contrast with patents, there is no requirement to use the invention. And so legal use, illegal use is just not an issue when it comes to satisfying the requirements for getting a patent. In fact, the office has been issuing cannabis-related patents all the way back to the 1940s. And cannabis breeders who have a special variety that they want to protect really have two options. One option is a plant patent, but that only extends to protecting clones. The other option is a utility patent, which is what we think of. That's the kind of patent that people use for all kinds of things, whether it's a new medicine, a jet engine, whatever, including you can use the same form of protection for a cannabis cultivar. And when you seek utility patent protection, you have the freedom to seek protection for all kinds of ways of defining your invention, including clones and seeds, and using it in breeding, and products derived from it, etc. So there's a lot more broad protection available with a utility patent, and it's actually nice for plant breeders that they've got both options. So the next question is, how do I know if my plant is patentable? A lot of people think that it must be really hard to patent something like a plant. And having done this for 24 years, I can tell you it's not as hard as you might think. your plant, in fact, is almost certainly patentable unless you didn't breed it. If you originally bred the plant, then you know that the genetics are unique. We know that the products of any kind of a cross are unique even among the siblings. So if you make 3,000 seeds from a cross, every one of those seeds is going to be genetically unique. It might be hard to tell them apart, but the absolute novelty of each of those selections is something that the patent office pretty much accepts. Statistically, it's impossible for it not to be unique. Okay, so the other thing that can keep you from being able to protect your plant is if you sold plants or seeds more than a year before the filing. If you did, it's very likely that this would be considered a loss of novelty and that you would not be entitled to patent protection. So it is important to think about the timing and to act quickly if you have sold something and it looks like it's really valuable, or you know it's going to be valuable and you haven't sold it yet. The third way to not be able to patent an original cross is if you simply can't distinguish it from another plant. If it looks like you were basically doing your breeding to mimic another plant that's already out there in the public domain, then at least theoretically you could get an obviousness rejection for that plant. I say theoretically because we've never had a rejection of a plant variety application that we couldn't overcome. In 24 years of doing this, we've got a 100% success rate in protecting plant varieties. We've had a couple of challenging ones, but we were able to clear those hurdles. But having had an interesting conversation with a plant examiner, they did say that they would reserve the right to issue an obviousness rejection if there were no meaningful differences between the plant that was for which protection was being sought and an already known variety. And so they've reserved the right to do that. That's at least a theoretical way of not being able to patent a plant, but it's just not something we've seen in real life. So if it's that relatively easy to qualify for patentability, the real question is the plant that you're working with worth patenting? That's a business decision. It's always about how much it's going to cost for that protection and how much of a return on your investment are you going to get for that expenditure. And I think a good rule of thumb, a good question that is worth asking yourself and that I often ask clients is, put yourself 5 years in the future with this variety and ask yourself, is the demand going up or going down? And if you think it's probably going down, then you may want to think about whether it's worth patenting. If you get to that point, you would also be asking yourself, I think, how many markets could I sell it into during that prime time, and how much would I expect to make, and how likely is it that someone would take it during that time and copy it and eat away at my profits? If all those things seem kind of remote, it may not be worth protecting a plant. But if you think the demand is going to be going up 5 years out, then it's highly advisable to get some protection on it. Another question that comes up all the time is, do I need to do a DNA sequence in order to qualify for patent? And the answer is a resounding no. It's surprising to very many people that in 24 years of patenting hundreds or probably thousands of plant varieties, we've never had to submit DNA sequence. And that really is because the statutes that established this kind of protection were around a long time before DNA sequencing was feasible or even was known. And so the requirements that are based on the statutes are a lot more fundamental to just the appearance of the plant, its ancestry, appearance-based comparisons between the plant and the closest known varieties. There are opportunities if you do have biochemical or DNA information, then it certainly is possible to use that information as a point of distinction. And it's pretty common that when we file a plant patent or a utility patent application on a cannabis variety and we have a certificate of analysis that shows the chemical profile, that we certainly will list that because those are important characteristics and they can be one of several ways that we could distinguish this new variety from existing varieties. And the more ways you have of distinguishing the new variety from existing varieties, the less likely it is that you'd get caught up on that theoretical technicality of the plant being obvious. Like I said, that's not anything I would really lose any sleep over. but it's at least a possibility. So yes, the more information you have, the better off you are. And certainly if you have the DNA information for other purposes, it would be great to use it, but it's just not essential. It is essential and extremely important to have DNA evidence when you're trying to prove that someone is infringing. And definitely in my career of helping my clients protect their plant varieties, we have used DNA evidence to show that something that looked like my client's plant really was a copy of my client's plant. And that kind of settled, it forced a resolution of the case right away because it just was not something that anyone could really argue with. But the point about that is you don't really have to spend your money on that unless you need it for other purposes. I'm not down on DNA at all. I'm a big fan of DNA information and its power and its utility. It's just not a requirement for patentability. But whenever it does come time to prove infringement, the point is you'll be able to go get DNA from your plants, and you'll definitely be getting DNA from the suspected infringer. You'll be able to do the comparison. It's not like your DNA information is going to change or won't be around. If your plant is, if you don't have access to the DNA, it means your plant is extinct. And so that's, even there, you might be able to resurrect it from some old samples. And of course, the great example of that is that, even a woolly mammoth, which has been extinct for 10,000 years, has actually been fully sequenced. So yeah, DNA information is great. It's just not essential to get a plant patent or a utility patent on a plant. Okay, another topic that comes up a lot is open source. Open source it feels good, it feels ethical, it's attractive. It's attractive as a concept and as a way of doing things. That began in the computer industry, and it has had a huge impact on the development and sharing of the hard work that goes into making original source code for different kinds of computer programs. And so open source works great in computers. Why shouldn't it work for cannabis? Well, unfortunately, you can't make an open source system work unless you have some kind of IP protection in place. And why is that? Well, I'll back up there. First of all, if when you say open source, you really just mean free sharing with anybody in the public, that's fine. But that's really public domain. And what I hear some people say is, well, I want to share with people who are doing a home grow or small companies, small growers, but I just don't want Monsanto to get it. And the fact is that if you don't have any IP protection on it and you put it out there, you can't control what happens with it after that. Now, a real open source system is a system where there's an agreement that everyone who participates in the system has to agree to be able to participate. And then it says, I'm not going to use this for certain purposes, or I'm not going to give it to anyone, or whatever. And anybody that enters into that agreement, you can certainly enforce against them if they breach the agreement. And that agreement itself gives you recourse for the violations. The problem is, what about the people who never signed on to that agreement? What about the people who have no contractual obligation to that open source system? If somehow they got their hands on your genetics and they didn't have any contract that you could enforce against them, you don't have anything without IP, because when you run out of contract rights that you can enforce, that's kind of where patent rights start, that you can enforce patent rights against people for their use, whether or not they ever agreed to anything. And the analogy with open source with real open source systems is that in software, there's automatic copyright protection as soon as you create code. And so they already have the recourse that you need against violators that never signed up. And that's why that works. But in the absence of IP protection, you can't really do an open source. Now, if you did have IP protection on your plant and you wanted to put it into an open source system, that would work perfectly well, because you'd have the agreements to rely on for the people who expressly embrace the open source system. And then if it slipped out of that system and it were someone infringing that had never signed on to any of those agreements, you'd still have the IP to enforce against them. I hope that makes sense. It is a somewhat complicated topic, so you might want to read the blog post about that. Okay, moving on. Sometimes people talk to me about the ethics of patenting plants, and I don't want to be dismissive of this at all. I think it's an interesting and genuine issue. Some people consider the plants to be so important medically or so sacred, the kind of relationship they have with them, it just doesn't feel right to patent the plants. And I'm not ever going to try to convince anyone who feels that way that they should feel differently. But I do want to just kind of explain things in a little bit different terms. If you think about the fact that a plant breeder is a creative person and they put, in many cases, decades of their life into developing some really special genetics. But unless they're going to hoard that, any kind of sharing makes it easy for some recipient to make their own copies. And that's probably fine if it's just across the fence to your neighbor or the people in your community, the people you care about. I think the history of the industry is that people were happy to do that, and it was considered one of the beautiful things about the community, and so on. But now that the industry is a worldwide industry and it's more of an industry now than just a community, you recognize that if someone gets even a single clone or some seeds, they can not only do their own thing with it, but they can actually build a competing business on the back of all your work. So if we compare plant variety, plant genetics with other kinds of easily copied creative work, we think about things like movies and books and music and things like that that we're all very familiar with, and they all have automatic copyright protection. And so all of those people, those creative people who make these things that we all like to enjoy, they already have IP protection in place, and that's how they get paid for their creative work. If they didn't have any form of copyright protection, people could just do whatever they wanted, including launching their own music label, theoretically, take with everybody else's music, and just kind of undercut their price. It erodes the value for everybody. So my point when I'm talking about this is that since plant breeders don't have any access to copyrights, they need some kind of protection. It happens to be patents. That's the option that is available to them. And I just ask, kind of rhetorically, but very seriously, why shouldn't plant breeders and their creative work have the same kind of value and protectability as other kinds of creative people? I personally believe that if a plant breeder wants to be able to share their work with the world without losing all the value as soon as they start to share it, and they would like to be able to have their lives, the thing they've devoted their life to actually support them, then I don't think there's anything less ethical about patenting plants for that purpose than there is with copyright protection. Now, I already mentioned, the people who would like to be able to share their plants freely with a certain slice of the community, but keep the plants from being accessed by big business or by someone who intends to just make money on the back of the other person's work. The nice thing about IP protection is you can choose how to use it. You don't have to enforce it against people you don't want to enforce it against. In fact, what I've recommended to some people is that if they really want to have their plants be available for home grow, and they just don't want some big ag company to grab their plants and compete with them, then what you do is you get nice strong IP protection. You grant a license to anyone who wants one if they certify that it's only for home grow, that they're not going to put it into some kind of a business, etc. So you basically have a home grow license that is free or minimal cost, but you don't grant that license to people who don't qualify for that use. And so just like a drug company could be free in theory to price its drugs any way it wanted to, or to have a sliding scale on the price of the medicine, or to just give it away to certain people. The same thing holds here. If you have patent rights, you get to decide how to use them. And the blog post at the top of this page goes into that. It is sometimes people get IP not because they want to keep the whole world out, but they just want to control who has access to whatever they've created that is special. All right. Now, suppose you've gone through the whole process of getting a patent. Then the question is, well, what can I do with patent rights? I remember when I was a new attorney, I was sitting in an initial consultation with a patent client, and the senior attorney I was working with said, you need to know we can get you a patent, but when we get you a patent, it's not just going to start raining money. You've got to have a plan for how you're going to use this patent to pay for itself. And I've always remembered that, and I think it's really important. It's very true. You look at a patent as a tool to help you achieve certain business transactions, like licensing the rights to other people who want to propagate it or cultivate it or make products out of it. That gives you a lot of latitude about how to commercialize the work that you've done. It also gives you protection, as we've talked about, for controlling who gets to grow your genetics. And if someone is growing without permission, you can shut them down. You may not want to in every case, but if you never can, then if you've got something really valuable, someone's going to come in and take it from you, and you really won't get a return on all the effort you put into the breeding. So a patent is a way of keeping out the parties that you don't want to have to compete with, or that you don't want to have access to your special plants. It doesn't mean that you can't share it with others. And then and certainly there are some limits to that. If you want to go into the detailed legal aspects of that, then we can talk offline sometime. If you put it out there freely for everybody but this particular person, that may not be something that you could enforce. But if you have a license structure that certain types of people in a certain situation qualify for, and other larger entities don't qualify for, that would be something you could definitely create. Another really important thing that you can do with plant IP is that it gives you the opportunity for global scalability without having to buy land and hire people. So, we think of plant IP or plant genetics as being, that's the thing that you plant in the ground and you grow it, and it's farm-based or indoor grow-based in either case. But if you wanted to make enough of something special to share it with patients all over the world and to tap into markets all over the world, you really don't want to have to buy facilities all over the world. There are people already there who have those facilities and the local capabilities, and they're clamoring for your great genetics. So all you need to do is have some IP so that you can do a license deal with them and let them help you with their scalability. And I have a great real-life example of that. A company that I began working with in 2010 they started off as just a fruit company. It turned out that they were good at breeding the kind of fruit that they worked with. And after about a generation of being in this business, they had a business that was yielding about $10 million a year. So that's a really nice business. But when I started working with them, they made a global a commitment to having a global IP strategy. And as part of that commitment, we filed plant variety protection all over the world. We helped them cultivate relationships and make deals all over the world. They were really the key to the relationships, but we helped them turn those relationships into great commercial partnerships and deals. And 10 years later, the result was that their business was then $200 million annually, so a 20x growth over 10 years. And they had also crossed a threshold where they were making more money from their IP licensing than they were from all of the still significant amount of production that they were doing as a business. So I think that's evidence that good IP really does set you up to be able to do some great things in terms of scalability. That is really the whole topic that I wanted to cover. Here's some contact information. We'd love to hear from you at the law firm. If you're an independent breeder and you would like to learn about how we work with independent breeders to help them license and protect their IP, then contact us at Breeders Best. And I'd also be delighted if you'd take a look at my blog. All right, thanks.